7:03 p.m. This open meeting of the Grafton Zoning Board of Appeals is being conducted both remotely and in person, consistent with the Chapter 22 of the Acts of 2022, which extends remote meeting protocols through March 31st, 2025. This meeting is convening via Zoom video conference and in person as posted on the meeting agenda, which can be found on the Town of Grafton website. Please see the meeting agenda for details on how to participate remotely. Please note that this meeting is being recorded. All participation within this meeting will be visible to others. Accordingly, please be aware that other people may be able to see you, and you should not screen share as it may be captured and rebroadcast later. This meeting may feature public comment. Anyone that wishes, anyone attending virtually, you'd like to request acknowledgement to speak, please use the raise hand feature in Zoom. If you're on the phone, our staff will assist you with recognizing you to make a comment. For those in person, we ask you to step up to the podium to speak, and all speakers, please state your name and address prior to your comments or questions. Finally, each vote taken during this meeting will be done on a roll call vote. So for tonight, there is 3 cases on the agenda, one of which requested a continuance. I'll defer to Vice Chair McCusker on the order and the.
Yeah, I think we should probably take East Street first and see if we can't finish that up.
And as I was absent and Vice Chair McCusker handled this case previously, I'll
want me to
ask
just go
him
with
to
it?
continue it. Yeah.
All right. So then at this point, we'll reopen case number 903, 25 East Street, a request to overturn the decision of the zoning enforcement officer. I guess perhaps I'll maybe turn it over to the applicant, and I don't know if you have anything new that you want to share with us, or change of heart maybe, or who knows what.
Well, we have lots of new stuff.
Okay.
First of all, let me just say, my name's Henry Lane. I'm here on behalf of the applicant, who was here as well. And I know this is going to be a little bit confusing for you, but we all come from different cultural backgrounds. And we have Carlos Baez and Carlos Baez. They're brothers. They distinguish by their middle names. Okay. So the first thing I want to bring your attention is that great progress has been made over the last month, and all the vehicles that were being stored outside have been removed. So I have a photograph of showing you the fenced-in area now being devoid of vehicles.
When was that picture taken?
Today.
Yeah. Yeah.
Do the color one.
Thank you.
And the reason that I start with that is because one of the items that's cited in Mr. Berger's cease and desist order relates to the general bylaws and the storage of unregistered motor vehicles. And that's section 15 of the general bylaws, which specifically relates only to unregistered motor vehicles that are not enclosed in a building. So I think it's very, very important for us to make the distinction that the prohibition cited in Mr. Berger's letter does not relate to vehicles that are actually stored inside a building. So at this point, it's our position that we no longer have unregistered motor vehicles stored in the building. We do still have unregistered motor vehicles that are stored inside the building, but in our interpretation of the bylaw, at least are now within the permitted, or within the limits of the bylaw. So I don't know if the town's had a chance to inspect the premises recently, but that's our position with respect to the vehicles being outside. So I think we've addressed that issue. I hope to the satisfaction of the town. I do have some additional pictures, but I think that you have the key one. Secondly, I know this is, well, this relates more to the accessory use question, and I think we tried to make it fairly clear at the last meeting that Carlos, who was the person that was on the lease of the premises, was not actually in possession of the premises. And I now have the documentation of the fact that that lease is canceled. So Carlos no longer has any connection to the property, he is no longer on the lease, doesn't own any vehicles there. He has really no connection to the property anymore. So I have copies of the lease documents here. Currently, prior leases.
Is that one copy or multiple copies
I
right
have
there?
multiple copies.
Have you seen it?
I have a copy of a lease that you gave me before.
Leases.
Is this one copy? Each stack?
Yeah. So what's essentially happened in this particularly to address the accessory use issue that Mr. Berger also raised. He was concerned that the actual name on the lease was not the person who owned the vehicles. But now we produce a documentation showing that the person who is on the lease is the person who resides there. So it is, now we've sort of cleaned up the paperwork so that it reflects the fact that Carlos, who was the original person on the lease, is not the lessee anymore, but now the resident is the lessee. So I think we've addressed again, it's mostly a paperwork thing because Carlos, wasn't actually occupying the premises. We've now cleaned up the paperwork so that the resident who lives there also is the lessee. So it's now connected to the resident. So I think we've addressed the question of it not being accessory use. He's a resident, it's his vehicles, he's the lessee. So again, it's a lot of paperwork there, but I think that addresses that issue. And I think takes that off the table. Thirdly, also an issue raised was the question of, and I think it was our testimony at the last meeting that the vehicles that are there are actually owned by Carlos Baez Armando, the actual tenant. And I have copies of the title certificates here.
And these are copies, these aren't the originals, right?
Those are the originals.
Okay.
I do have copies.
You probably want to hang on to the originals, I would think. Why don't you just
Yeah, I
take
wouldn't
those? I don't want to,
You don't want to own the vehicles?
I don't, worse, I'd lose the titles and then we really got a problem.
Well, you own those vehicles, you'd be in violation of the bylaws. So, as I said, since our last meeting, I think we've done our best to try to address the question of the outside storage of vehicles. I think we've taken care of that. I think we've taken care of the question of whether this is accessory use or not by updating the lease agreements to reflect the actual situation. We've addressed the indoor storage of vehicles. The one issue that is still outstanding in our view is the question of the watershed overlay protection district. And I know we talked about this briefly at the last meeting, but I'll just go through it briefly again. The bylaw does talk about servicing motor vehicles, but in our view, the context of that bylaw was not intended to address the situation we have here, where we have an individual resident who is basically a car enthusiast and working on his own vehicles. So if you look at the regulation, it prohibits motor vehicle salvage operations and junkyards. I guess we've taken care of that issue. And then it talks about airplane, boat, train, and motor vehicle service, repair, and painting operations, including auto body shops. In our view, the fair interpretation of that section is that you can't be an automotive repair garage. You can't be commercially involved in repairing motor vehicles for hire, shall we say. The way I read that when it talks about, operations, that suggests to me that it's a business. Because the alternative interpretation would be, if you took it literally, would prohibit things that many of us do, not every day, but periodically. For instance, something as simple as washing your car is servicing a motor vehicle. And if you take the very broad view of this bylaw, you would basically saying that in about half of the town, you're not allowed to wash your own car, because that's servicing motor vehicles in the water supply protection overlay district. If you got a flat tire on the turnpike, you could not repair that because that would be servicing a motor vehicle within a watershed protection over district. You couldn't theoretically even tow the car because that's servicing a motor vehicle. You couldn't inflate a flat tire. You could not replace a battery. If you run out of gas, your car would have to remain there forever because towing it would be a service. Putting gas in it would be a service. Almost anything you do to the motor vehicle would be a service. So in our view, the only rational interpretation of the prohibition against service, a motor vehicle service operation, means a commercial operation, not an operation where people are maintaining or have a hobby of dealing with their cars. They have a car collection. You can't wash your car collection. You can't change your own oil. You can't you can't inflate your own tires. You can't change tires. You can't put on your winter tires if you're in a watershed protection overlay district. So I don't think that's a rational interpretation of the bylaw. What it intends to mean is, look, you can't open a automobile repair garage. That's what it's intended to go at. So, so I guess in summary, and Mr. Baez and Mr. Baez are both here, but in our view, I guess we're basically asking the town to do a number of things. One is to recognize that we have gotten rid of the unregistered motor vehicles that were not inside the building, to recognize that motor vehicles inside the building are allowed by the general bylaw. Thirdly, that we are no longer an unpermitted non-accessory use, but we have brought it into compliance. That is now an accessory use, so we've complied with that portion of the bylaw. And finally, that repair or fiddling with or restoring your own motor vehicles that you own inside a building is not prohibited in a watershed protection overlay district. And I think, the board has fairly broad discretion to impose, to interpret the purposes of the bylaw. And I think this board can and should interpret that prohibition against motor vehicle service operations to be addressed at commercial garages, not at people who have private car collections and fiddle with their own cars inside a building. So that's basically what we're requesting. I think we provided the documentation to support that, and we would ask that the board adopt a vote to that effect.
Thank you. Any questions for attorney before he sits down? Okay. You want to say something?
I would, yeah, I would
Okay,
like to say,
name and address for the record. Bill.
I'm George Audi, owner of 25 East Street LLC,
Yeah.
that rents out the property. So I would like to give out this letter of the ongoing, because I feel like you have to know the background to this, because he's been sending these letters, the same zoning violations to you guys when the property was empty. I've been getting these letters from him for 5 years. Even when I had the property for sale, you can go on realtor.com.
You got to go back to the podium, please.
So you can go back to realtor.com when I had the property for sale, which actually didn't sell because of Bob Berger. He had the previous attorney, Jeannie, write a letter to my buyers saying that, which is completely false, I've consulted many lawyers about it. He told them, even though I got the A&R split, that if something were to happen to the dam, the town could sue them for the house. The email went from Jeannie to Bob Berger, then he gave it to my buyers. I mean, I still had that violation from him with the garage empty, with the whole property empty, with the whole house empty. I had those same violations. This all goes back to, he wants the lift out of the garage. He has an ulterior motive because somebody wants him to take the lift out of the garage. And he's trying to find any way to take the lift out of the garage, which I'm not violating any rules for having the lift in the garage. And this will never stop. He'll keep doing it, and he'll keep doing it, and he'll keep doing it. Just so you guys know. Thank you.
Mr. Vice Chair, can I address that?
Sure.
2018, this went to housing court a couple times, but the first time it went to housing court, the judge ordered the lift to be removed. Bob Berger didn't order the lift to remove. The judge ordered the lift to be removed. And we have been going forward over the years just so I could go into the property and inspect the property to see if those orders have been complied with. That's what we've been doing since 2018, and we finally got in 2024. So everything has been, going forward just to get in the property to verify the original orders from the judge. And there's not just one, there's 3 orders from 3 different judges that keeps on using the same orders of condition to stop the violation.
Thank you.
And again, if you read my letter, you will see how he got those orders, was sending notices to the wrong addresses with false information.
Okay.
I cannot see how a town official can lie under oath in front of the judge and present fake information, which she knows is fake.
All right. We need to focus on the order that's in front of us. All right. I'm trying to find the original letter. So we're here because the request has been to overturn Bob's order. Right here, right? the approach that I'd like to take, and I talked a little bit offline with town council about this. Bob, in his letter, has basically said that, he's ordering, the applicant, I guess, to do 5 things. And I'd like to take each one of those, individually and basically do a motion to overturn that particular item, and I'd like to do it one by one. That's kind of where I'm headed here. Now, we're not going to vote on anything right now. We still have an open hearing, and I do kind of have a couple of questions for our council. Specifically, if we look at the first order, right? Order to cease and desist operation of an automobile and or truck repair garage. Now, I don't think it's in dispute that the bylaw doesn't allow that. I don't think that's in dispute.
No.
I wouldn't think that's in dispute. So I can't imagine why we would overturn that order. Now, whether they are or aren't operating an automobile garage, does that matter? I mean, Bob hasn't said, the order isn't, that's what I'm trying to figure out. I mean, the order is to not, to cease and desist an automobile. I guess if we say, if we uphold this order, then we are implicitly saying that they are operating a repair facility. I guess that's really what it comes down to, right? We are implicitly
Yeah, and-
saying that.
Yes, and, an auto repair or truck repair garage is not defined in the bylaw.
Right.
So part of that, the board would have to determine, how you all interpret what that means.
Yep.
And that's where whether it's a business or a home hobby, those are, that's an argument against the order. But, the board has to kind of define what, you think that means, and then that goes into whether you uphold it or not.
Okay.
Or, the other option as well is if you think for any of the orders, this might not apply to the first one, that if the order's been complied with, based on the new information you all got tonight, you can, deny and state that it's moot because they complied with the order. If, for example, if you think they complied with the order having to do with the cars, I don't think you need to overturn Bob's order, but they complied with it. So it's just moot. And
So, okay, I'm glad you brought that up, because that brings me right to the next point I was going to ask. So number 3, order to cease all storage of motor vehicles located on the property violate the Grafton zoning bylaws. I don't know why I would overturn that. If they've actually are complying now, great. But that's, I can't help but feel that if we were to overturn that, or I should say, if we were not to reaffirm it, essentially, but if we were, then, that opens the door for them to actually store, the vehicles. And by the way, we were showing a picture. We really don't know. For all we know, they moved the cars out onto the street, took the picture, and put them back, right? So we don't know because Bob hasn't gone in to inspect. And I'm not saying you. I'm not saying you did that.
Time to go.
I'm not saying you did that.
You can go anytime, look at it.
He can go anytime, look at it.
So that was my next thing.
To,
My next thing is, if you guys read my letter about my complaint to Bob,
yeah. By the way, that's not
and
gonna
you
get
feel like
recognized.
it's fair for him to, so one of the meetings, I've requested a record request, by the way, which of course they denied me because it's gonna show proof that I'm right. Which, why would they deny me my record request? Why would the town attorney, every time I go talk to any
Let's
department-
focus on tonight.
So I did go to the town clerk to get the record of when we were in court. Jeannie said the town recommends that Bob recuse himself off this case because they know he's biased, because they know he's harassing me.
They never-
And the assistant,
They never.
and the assistant building
never
inspector
said
take
that.
over.
And
They
I'm
said this in
sick
court.
Of the lies.
And then he said Bob Berger and me, myself, Jeannie, believe this isn't true. So he wants to keep himself on
Bring
the
it to
case.
tonight. What does that have to do with the
So
order?
I was saying everybody in this town, everybody in this room is allowed on my property, but him. This has to be a point somewhere here. So
All right,
you know
fine.
what it took to
Got
get
it,
those
got it,
pictures?
Got
I'd like
it.
to
Got
remind
it. Got it.
Sorry.
You just said he's not allowed on the property.
Yeah.
Got it.
And I'd like to say one more thing. The only reason, first of all, you go interview everybody in that neighborhood, There's never been 10 years I've owned that house. I've been pouring money into it, making it look better. And anybody that lives in that area knows what that house looked like before I owned it.
Okay.
You go interview everybody, they tell you nobody's seen anything behind that fence. Imagine like if everybody in this room, if you're gonna start looking, you're gonna find something everywhere. If you're gonna start locking up everybody, put them in jail, and have the judge tell you you're not gonna get out of jail till you let
All right.
the inspector into your building, you wouldn't. Nobody would have had seen those pictures.
You're, okay.
But that's what I'm trying to get to. They had to
Understood.
put me in jail to get him to go in to get those pictures.
Okay.
He's sitting there taking satellite images of my house. Why
am
is he?
not
Why is he
taking satellite
harassing me like
images
that?
of your house.
He's taking
I'm not, all right,
copies
that's
of
it.
them.
Please sit down.
I'll sit back down. Sorry. There's just 10 years of this going on. That's why
Fine.
I'm this emotional about it.
And I'd rather this
So
meeting
much.
not go on 10 years, so we need to stay focused. All right, so, in my opinion, as we look at like the item number 3, we're order to cease and desist all motor vehicles. Even if they have complied with it, it seems to me that we should still make a decision about whether to overturn that order or not. As opposed to just saying
Right,
it's
because if
moved.
you overturn it, then it could all just go back tomorrow.
Right,
In
exactly.
theory.
Right.
In theory. I'm not
So-
accusing them that they're gonna do that, but
Right.
in theory, that
Right,
could
so
happen.
it seems like we really should be, reaffirming these orders. And if they've complied with it, great. And if they're complying with it, then they shouldn't mind it either.
Well, you're overlooking the question of the motor vehicles stored inside the building. Unless you're going to make the decision that you can't store them inside the building, if you affirm that order, then we have to take the.
Why, do they just, do those, or the cars inside the building not comply with the bylaw?
The bylaw says you can't store more than one unregistered motor vehicle on your property unless they're contained within a building. That's what the bylaw
All
says.
number 3 says is cease and desist storage of motor vehicles located on the property that violate the town of Grafton zoning bylaws.
Well,
If
but
you're
that-
saying,
but see, if you affirm that, you're leaving us with nothing because we don't know what that means.
what do you mean you don't know what that means?
Well, we don't know how you interpret the bylaw. It's the same question that we have with respect, to the bylaw that says motor vehicle repair operations are prohibited. Well, if you just affirm it without defining what that means, we're nowhere. Because we can just go on and say, well, we don't interpret this to be an operation. Or we don't interpret this to be a storage of motor vehicles in violation of the bylaw. You got to make it clear that if you're going to affirm the requirement that we remove motor vehicles, it only applies to more than one unregistered motor vehicle outside of the building.
I don't understand where the ambiguity is. Keeping of more than one unregistered motor vehicle which is assembled and roadworthy shall not be permitted unless said motor vehicle is stored within an enclosed building.
Right. So if you affirm the order, you just have to put in there that it only applies to vehicles that are not stored within a building. That's all I'm asking.
I disagree that we need to put that in there. It's already in the bylaw. So I disagree with you on that one. Okay, got it.
Then let me make it a request so that going forward, we don't have any confusion about that, okay? Because the order does not say anything about in or out of the building. And we just want clarification that you're not saying we have to remove vehicles that are inside of the building. I just think that's fair to us to make it clear that you've made that distinction. I know what the bylaw says. That's why I'm here. But if you don't put that in your decision, then it's still ambiguous because it doesn't tell us. It's up to us then to again reinterpret and guess, what you intended.
Point taken.
So see, it's a reasonable request.
Got it. Got the point. All right. All right. Any other questions? I think we're at a point where we can close the public hearing. Does anyone have any questions for the applicant? And is there anyone in the audience here in the building that would like to speak to this case? For or against? And then it looks like we have nobody on. There's 2 participants. Is that you and Bill?
Yeah, we don't have any attendees.
Okay.
Bill,
Yes.
I have a question.
Go ahead.
You brought up the point that it's in a watershed protection overlay district.
That's correct.
It's also in a wellhead protection zone, area 2. So it's more than just being in the overlay district. That parcel is part of a wellhead protection area, Zone 2, which is an area that has been designated to protect the wells on East Street and the well on the area behind the Stop and Shop. So to my mind, it's more significant than just being in the overlay district. And the other point that I have a question in my mind, it seems as though, if I have a court order, I don't ignore it. If I'm told by a court officer or a judge that I have to do something, then I guess my question is, why wasn't it done?
Well, there's a complicated legal reason for that, primarily because the original enforcement order years ago was not properly served, so we never had an opportunity to come to the zoning board. The zoning board has the initial shot before the court can enforce an interpretation of the bylaws. This board has a right to weigh in. So initially, since the service was not, in our view, was not proper, and again, that's a legal issue whether it was served properly. In our view, we were not given an opportunity to come to this board because we didn't get served with the original notice in a timely manner because there's a deadline on how long you have to appeal. So we were foreclosed on the initial order. The new order, was properly served, and we appealed it in due course, which is what you're supposed to do, okay? This board has first crack at the interpretation, all right? So unfortunately, it went in reverse here. I wasn't part of that process. I don't think the current town attorney was part of that process. That's all history. At this point, we're dealing with the enforcement order that was issued to Mr. Baez. He has not had an opportunity until the hearing a month ago to be heard, okay? But we have to get your interpretation. That's what's important at this point. What the court does with that afterwards is something we can deal with. But ignore what the court's done. None of that has any bearing on what you're doing. It's your decision, not the court's, to interpret your bylaw in this process, okay? Simple as that. It's an entirely new proceeding. Mr. Baez is the applicant. Nothing that happened prior to this hearing is material to this decision.
Thank you.
I'd like to answer his question too about we're in compliance with conservation, DEP, EPA. That building is sealed. Nothing is at any risk to any wetland protections. Zero risk. They're more than welcome to come do inspections. I've never got one letter from them. Nothing could ever, the building's sealed, nothing, there's never been a risk of anything happening. If there was, and then they're more than welcome to do any inspections they want. I'm not in any violations with them. And to answer your question about not complying with the court, well, one of them was because the house was in my dad's name, and I was calling the building inspector, telling him, hey, my dad's 75. You can't keep dragging him to court like this, making stuff up. Because obviously my dad's 75. He doesn't open his mail. My dad missed all the mail, can barely see. He's on oxygen eyeglasses. So he missed all the court orders. He went in with fake evidence, fabricated evidence.
You know what,
And-
I'm not gonna.
Okay, I won't say that again.
Yeah.
So,
If-
but
so
what happened was,
if you have
that's what
something
happened.
new to
That's why I was
add,
answering him.
You've already said those things.
I won't say it again. Okay, I won't say it again. But so what happened was, I ended up telling him the property's in my name. Can you please start sending me the cease and desist in my name? What'd he do for a year and a half? He kept sending letters to my dad. I kept begging him. I'm like, hey, then I called the court. I'm like, hey, court.
We've
please.
been through this before.
But that's why that's why I'm
Okay,
answering
understood.
this question. That's why I didn't
Got
let him in. So then finally the court dismissed it once they found out the property wasn't in my dad's name anymore. Then I moved to Florida, and then I showed, there's records. When I moved out of the house. The house is sold, and they're sending the letters to the house I moved out of. So by the time I came back, it was too late. By the time I found out about it, the order was already issued. Nobody, and then that's why finally we had a chance because they kept saying, we think something's going on there. That's it. No evidence, nothing. And then finally, when they added him, the judge dismissed all the previous cases they ordered on once they found out what was happened. Everything got dismissed.
They didn't do that.
Even the previous judge, the girl that issued, she dismissed it. But the first time they issued.
None of this is really relevant.
But that's why I just wanted to let him know. I
Okay.
only answered his question.
All right, thank you.
Thank you.
All right, any other questions from the board for anyone?
Mr. Chair, I have a question.
Yeah.
I think they did a good job providing a lot of the documentation here, but I'm just curious, I don't know if this matters or not, but out of all the titles that they've provided, not all under the tenant's name, does that matter? I don't know if that matters.
The back of it, the ones that don't have, the ones that say different names.
Yeah.
It's because they sold them to me, so I have to put my name on the back of that, the title. So the original title has them.
Yeah,
They're all on there. All the names are on the original titles.
yeah, unfortunately,
I don't know if you
Oh, on the
copy.
original copy, you're saying?
yeah.
Oh, okay.
Yeah, they've all been assigned. Just they haven't been
Right.
re-registered yet, but they've all been assigned. Yeah, you want to see them again?
Yeah, look,
Yeah, look at the backs.
No, we
You
believe
can
it.
see the names. He just hasn't registered them, so they didn't issue them. These actually have the backs. This copy has the backs on them.
yeah, awesome. No, I was just curious.
Let me just make sure.
Alex, as soon as you're done with those, I'd
Yeah, give it
like
back.
to give them back.
Yeah, can I?
Yeah, awesome.
But you can keep the copies. I made
Yeah.
copies of those. You can
No,
keep
the
those.
originals, I want the originals out of here.
I don't want to lose those.
All right, at this point, I can't remember how we do this. I'll entertain a motion to close, case number, whatever this is, case number 903 to public input.
So moved.
Second.
All right, motion made and seconded. Any discussion on closing the case? And on a roll call, Mr. Thomas?
Yes.
Ms. Reed?
Yes.
Mr. Yeomans?
Yes.
Mr. Mayhaus? Is that how you say it?
Mejia.
Mejia?
Yeah,
Mr.
yes.
Mejia? Yes, and Vice Chairman votes yes, so we're closed. So look, I think we, as I said, unless anybody has an objection, please let me know, but I think we want to take these in individually. Town council and I went back and forth a little bit on this, and, I think it makes more sense to approach it from the point of view of, I move to overturn the building commissioner's order, as opposed to, I can't remember what the original words were, but it was kind of the other way around. So we have, I think everyone has in their packet these proposed motions. And I think at this point, we should just take them one at a time and we can talk about them. So if somebody wants to make the first motion, please, and then we can discuss.
So, okay, I move to overturn the building commissioner's order to Carlos Baez to cease and desist operation of an automobile and/or truck garage, repair garage at 25 East Street.
Second.
Okay, so motion made and seconded. So my opinion on this is, I disagree with council's opinion that, changing a tire, qualifies as operation of an automobile, truck, or repair garage, right? And I don't think there's any, as a matter of fact, there is nothing in the bylaw that says it has to be a commercial operation, right? It just says use. It's the following uses, and not all uses are commercial. So I think at this point, in my mind, in my head, I just have to look at it and say, that's not a typical residential operation. That's not the type of thing that happens in, that's not happening in my garage. It's not happening in anyone's garage in any neighborhood I know of. That's not a standard, typical residential use. And I think that's, I think what's happening in that building is exactly the type of thing that the bylaw is speaking to that should not be happening there. And even if it was a collector, let's just say it was a collector who's got this collection and wants to work on it, I think there becomes a point in time where, or there becomes a threshold where, that's not a typical residential car use. So in my mind, I see no reason to overturn this order. And I believe that what's happening there, fits within what, what should be ceased and stopped.
Mr. Vice Chair, I think I said this at the last meeting. I still struggle with the fact that how can we tell someone that lives in this town that wants to work on cars or owns cars that this is the number that's normal, but once you go beyond that number, it's not normal. I mean, how do you say to someone, it's not in the bylaw, you can only have 3. So if somebody has 30 and they've got the space for it, I don't see how we can say, just because of the size of the garage, if it's all inside and it's not outside, I feel like we're limiting someone's livelihood of something they enjoy. I mean, if we've decided it's not an automobile truck repair garage, if we don't think that's what's happening, and these gentlemen just have cars there because they love cars, I don't really agree with. I mean, I feel like we have to look at, as long as they're not breaking the bylaw, which we're saying, we're agreeing it's not a truck or automobile repair garage. Are we?
We're agreeing it's not a commercial
Right,
operation.
Exactly. It's their property. So that's just my opinion on that.
Yep. I can't disagree with what you just said. I mean, I don't know where we draw that line, and
I mean, why does a line need to be drawn on the number or the size of that building if the property
Yeah.
allows that size of a building to be there?
Especially,
I looked at those pictures and I'm just saying that looks like a truck repair garage operation. Mr. Thompson?
Just especially if they've moved everything inside the garage.
Yeah.
They were doing it outside. That would be a different story.
Other,
I think one of the words you used explaining it was a typical, what you typically see someone doing, or the number of vehicles typically. And I don't think that matters what's typical. It could be atypical, but it doesn't make it,
Illegal.
a violation of the bylaw.
okay. Other comments? Hearing none, then we should vote. Now, just to be really clear here, the motion is to overturn the order. So if you vote yay, you're voting to overturn the order. If you vote nay, you are voting to not overturn the order. So yay overturns the order, and what is happening there, in theory, can continue. Nay means, the order stands and they have to stop doing it.
But just another last question.
Yes.
It says that it is a automobile truck repair garage. Who concludes that? So if like he says, that's in dispute, how are we voting yes or no to overturning that? Because we're not agreeing that there's enough proof to say that this is a repair shop.
It's a really good question.
well, the board is the one who has to decide, and the
Well, I
know-
thought we, discussed last time, and again, do we need more photos? Do we need somebody to go out there? Like, they're saying that, they're saying it's their personal vehicles. They like cars. They like working on cars. Is there a cash register in there? Are they collecting money? I mean, if it's a
almost like
repair
they're-
service garage, there would be money coming in and out, be people coming and going.
It-
I don't know.
Nobody goes in there at all. I
Yeah.
work until 5, 6 o'clock.
And you go in at night.
Nobody goes in
Yeah.
there.
I just-
The
But-
public comment is closed.
Yeah, it is. But it's not, it doesn't say commercial. It doesn't have to be a commercial.
Right.
Right.
Right, that's the thing. I don't know, there is no definition, so all I can go by is what I see. And that just looks to me like, and that's me. That looks like a, operation of an automobile truck repair garage. I mean, that's what that looks like. I mean, if you asked me to describe one, I probably would describe exactly what you know, what's going on there. So, and I think it becomes kind of an individual thing. I mean, I don't know. I don't.
And the line just says that not to operate one. And if we say yes, I think it's the building inspector's responsibility to declare, is it or is it not? All we're saying is the bylaw says not to do it, and we're agreeing with that.
Is that accurate?
No,
I mean,
well,
no.
the
I
building
think-
it's the building commissioner's initial determination on an enforcement order.
Yep.
It's been challenged, and you know the board's the ultimate authority to tell everyone what the zoning bylaw means. So it ends up being the board's
Yeah.
So in-
definition.
In light of all this evidence being presented, can the building inspector show us why we still consider this as a repair garage? Just based on everything we said here. What's the facts that declare this?
You look at the pictures, everything that was outside, they're saying now is inside. And they're working on the cars at night. And if they were doing it out there and they're doing it inside, then it's the repair. And this is not ordinary. And under the Section 7 Water Protection Overlay District, this is even with hazardous material above and beyond ordinary quantities. So, you know, and they're in the floodplain, they're in the well protection, they're in the Water Protection Overlay District. They get three things just talking about water. Did I answer your question?
Partially, but I think those are valid concerns, and we can put some clause over there that say, you know, there's some measurable evidence of oil leaking.
Well-
Or something to that effect, right?
You know, and I don't want to overstep when I'm talking, but, you know, this is not staying here. We know that once this decision is done and filed, the next thing is going to happen is going to the courts. So all I'm asking is don't overturn, you know, because I'm biased, don't overturn my decision. And if they have a problem with the outcome of, council has a problem with that, it's going to be heard by a judge. So there's no question about it that after this is done, it's going into Worcester again.
You know, I don't, what's lacking is a real definition of what it is, right?
garage.
And I don't think we're in a position to write that definition.
And factually come up with, yeah, they are
Right.
operating a garage.
Right.
So all we'll be agreeing here is, yeah, we agree, do not run a repair shop.
I desperately want to just do that,
Yeah.
right? The order says don't do that. The order says don't break the law, right? And I desperately, but we can't. It really is beyond that, right? Because, you know, it's more than just don't break the law. It's the Bob has said they are, and they're challenging whether or not they are, right? He wouldn't be saying cease and desist if they weren't doing that, right? So, you know, and are they doing it or not? There isn't a definition. So this member of the board is just going off of my gut. What I see from the pictures, what I see as I've driven by there, you know, I just go by, you know, my gut sense of this is, you know, this sure looks to me like what would be a repair facility. You know,
Can I just add one thing?
yeah.
So I think the contention is that this is a prohibited use, right? As a, where was it? Not a motor vehicle salvage operation.
A truck
Who's down
repair
there? It's just
garage.
This one here is what.
Okay. Every other use under this section seems to be commercial in nature. There doesn't seem to be any other item here that prohibits something that someone would be doing on a personal level or as an individual homeowner.
Well, I don't know. I mean, go up form, C4, right? Storage of, you know, chemicals, fertilizers greater than normally associated with household or agricultural uses. I mean, It doesn't necessarily mean commercial.
Well, normally associated with household or agricultural uses. If someone had a large plot of land, they would have could have a large quantity of chemicals or fertilizers, and it would be normal for that piece of land, but not normally associated with household or household use.
Yeah, and it would help if C8 had that same language, right? You know, not operating a repair, painting operation greater than normally associated with household or agricultural use. It would be great if that had that, right? But it doesn't. But
The context within this section, though, seems to point to commercial operations.
And have we designated that this is personal versus commercial?
well, we haven't because it doesn't say it has to be commercial, right? In uses, it doesn't, you know, it's just uses don't necessarily imply commercial. I mean, there's residential uses. There's different uses that it doesn't have to be taking in money. You know, and you think about it, if they actually were, they had the exact same stuff they're doing, but they're actually getting paid for it. So now that's not okay. But the fact that they're not getting paid, it is okay.
And we're basically saying to them that they're not telling us the truth when they say they're working on their own vehicles.
No. I'm not saying that at all. I'm not saying at all. All I'm saying though is that, you know, if they're working on, you know, 3 or 4 different cars and they happen to be theirs, that's okay just because they're theirs. But if they're working on 3 cars that were somebody else's that they'd eventually get paid for, that's not okay just because they're eventually going to get paid for it. I don't know where that how do you draw that distinction? Especially when we're talking about the overlay district, right? So, you know, it doesn't matter whether they're getting paid for it or not. It's the activity. All right.
Very complicated.
It is. I don't think it's black. It's not black and white.
Black and white at all.
It's not black and white.
No.
Other comments from anyone?
No, move on.
All right, then let's vote. Again, the motion is to overturn, so a no vote stays the zoning enforcement officer. A yes vote overturns it. Mr. Thomas, how do you vote?
No.
You vote.
No.
Ms. Reed,
Yes.
Mr. Yeomans,
No.
Mr. Mejia,
Here.
Mejia.
No.
Vice Chairman votes no. Okay, next one. Order to remove the automobile lift. So again, if you don't mind reading
Yes.
everything.
I move to overturn the building commissioner's order requiring Carlos Baez to remove the automobile lift from the 25th East Street property.
Second.
Motion made and seconded. Discussion? So this one, I struggle with. I understand that a court has ordered, him to remove the lift. It seems to me, and correct me if I'm wrong, it seems to me that if the court has ordered it, then that's a court order, and we can't overturn the court order. But I'm not aware of where in the bylaw it says you can't have a lift. So I struggle with this one myself. I don't know.
I'd agree, especially because it's inside the building. It's almost saying you can't have a bed in your bedroom or you can't have a bed in your living room. Unless it's a structural violation.
Mr. Chair, or Mr. Vice Chair, just to clarify, it's in there because we're trying to uphold the judge's orders. And the judge wanted me to go in and verify what was going on. You know, was his orders complied with? Orders are not complied with. And again, after this is done, it's going back up to Worcester.
Why did the judge, go ahead.
I think
You're gonna
you're
say
asking the same
something. Why did the judge order it to be removed?
Came to the conclusion that it was repair. And the judge saw the same, I'm sorry.
No, it's okay. Go ahead.
The judge saw just about the same pictures that you saw.
But was that a proposed order submitted by the town?
No, absolutely not.
Mr. Vice Chairman, please ask the town attorney whether the judge's decision on this has any bearing on this board's decision.
I think I already know the answer to that, but,
No, I mean, the board wasn't ordered to do anything.
yep.
It's standalone. I think to answer the question, why the judge ordered it, I think in the context of enforcement against, Mr. Berger's opinion that it's an illegal auto repair operation,
Yeah,
that the lift is intertwined with that operation. I do understand the point if like in a standalone garage, someone can have a lift, but I think in the context of all the circumstances, the lift was related to the
yeah.
illegal activity.
And I can understand how that would, exactly how that would flow. But from our point of view, from the zoning Board of Appeals for Grafton, who deals with zoning Grafton's bylaws, I don't think that this is something that we can,
The board would not be violating any court order
Right.
if you were to not order the lift removed.
yeah,
That's something that can be dealt with. in
right.
And
Another
it doesn't
forum.
invalidate the court order.
No, it
No.
doesn't invalidate it, and, yeah, all right, so, further discussion? Again, nay, upholds Bob's order, yay, does not. So we'll vote. Mr. Thomas?
Repeat it again. You said you.
So if you vote no, because the motion is to overturn, so if you vote no, you're upholding the order to remove the lift. If you vote yes, you're overturning the order to remove the lift. Bob's order to remove the lift.
Yes. I vote yes.
Ms. Reed?
Yes.
Mr. Yeomans?
Yes.
Mr. Mia?
Yes.
Vice Chairman votes yes. Next, number 3. You're doing such a good job.
I move to overturn the building commissioner's order to Carlos Baez to cease all storage of motor vehicles from the property that violate Grafton's general bylaws, Article 15.
Second.
Motion made and seconded. So this one, this one, the bylaw talks about outside storage. I'm not seeing the ambiguity that council seemed to be alluding to as far as indoor, outdoor. I think the bylaw is clear. It's in our attorney's letter to us, wherever it went here. Keeping of more than one unregistered motor vehicle which is assembled and roadworthy shall not be permitted unless said motor vehicle is stored within an enclosed building. I don't see any ambiguity in Article 15 of our general bylaws. I don't, I'm glad that they have cleaned this up, but I don't think there's any reason for us to overturn the order. The order should still stand.
As long as they're in compliance.
The order should stand.
Right, right. As long as they've done what this states, it doesn't really affect anything because they've made the change. Okay.
That seems to be in my,
Does that make sense?
I think it does.
Yeah.
It does.
Any other discussion?
No.
All right. We will vote. Mr. Todd, again, so a no upholds the order, a yay overturns the order. Mr. Thomas?
No.
Ms. Reed?
No.
Mr. Yeomans?
No.
Mr. Mia?
No.
Vice Chairman votes no. Next one, which is for the use of the accessory garage, an automobile, truck, or storage facility. This seems like a repeat of number 1, but go
Yeah, it
ahead.
does. Yeah. I move to overturn the motion is I move to overturn the building commissioner's order to Carlos Baez to cease use of the garage as an automobile and/or truck repair. It is the same. This number.
Sure is.
Second.
Motion made and seconded. Now, is there a difference?
Yeah, because the standard is different.
Okay.
Whether,
Right.
and remember, at the time this order issued, the rental situation was different, right? And that's part of what you have to consider. And if you consider that they fixed it, then that's okay too. But the first,
Oh,
the
it's
first one was.
accessory, that's the difference.
To the,
Right, so the first order, had to do with a, direct violation of the, section 7
Yep.
of the bylaw. This, it covers the same facts, but it's also, you'd have to determine whether it's, an accessory use to the two-family
Right.
structure, which is the primary use on the property.
So since the lease agreement was changed, does that have any play into this particular condition? Because of the ownership and change the name of the, who was on
I think
the-
that was a portion of what I think there was a couple issues, but one of the issues was that it was being rented as a freestanding garage,
Right,
not related to anyone,
right.
well, related, not directly related to the person living in the house.
Right.
But they've seemed to fix that.
But, I mean, you just saw that lease for the first time right now. Yeah, so we haven't really have a chance to review that, but even if it has, I don't think that's reason to not, I don't think that's a reason to overturn the order.
Agree.
I agree. I don't think that
Yeah.
is ample
But-
reason to overturn the order.
So I have a question.
Yeah.
If we uphold this,
Uphold the order.
uphold the order that they have to cease use of this accessory garage as an automobile and truck repair, and we're saying, yes, we agree that needs to happen, and then how does anybody go back and they're still working on cars at night and doing their thing? Where does that end? Like, where do they say, I'm still just working on my cars? How do we know that this order is being followed, that we uphold?
Like
Where
with
does-
anything else, it just becomes more it's just an
Just
enforcement issue.
enforcement from the town, what through
The
building
commission, yeah.
inspector and all. Yeah, okay, all right.
Any other discussion? Again, a no upholds the order, a yay overturns it. Mr. Thomas,
No.
Ms. Reed,
No,
Mr. Yeomans,
No,
Mr. Mia,
No.
Vice Chairman votes no. And then the last one is, deals with the inspection. Now, this happened, but I think it's a similar circumstance. I don't think there's any reason for us to overturn it, but, if you can make a motion.
I move to deny the building commissioner's order to Carlos Baez to allow,
Whoa. Why is that written that way?
move to deny the building order to allow an inspection of the property as moot. Because the building commissioner was able to conduct and inspect
No,
on
You
June.
can, so instead of deny, you can use overturn.
Yeah.
The reason it has to be voted on,
Oh, overturn, okay.
yeah, that's my fault. The reason it has to be voted on, because if you don't act on something, then it could be
Okay.
constructively approved.
Yep.
So even when something's moot like this, because the inspection happened, you still need to take a vote to close it
Okay.
out.
Do you want me to read it again?
Yeah, so
Okay.
deny gets
I'm-
changed over
To
to.
overturn. I move to overturn the building commissioner's order to Carlos Baez to allow an inspection of the property as moot. Because
No.
that seems weird too.
Yeah, wait,
Property as.
This one didn't get updated.
No,
from,
it
So it's
as-
to allow inspection of the property, and I think
As-
the rest of it,
Forget the as moot.
yep, just
Okay.
that all goes away.
To allow an inspection of the
So-
property because the building commissioner was able to conduct and inspect on June.
To allow, no.
Inspection of the property?
I move to overturn building commissioner's order to Carlos Baez to allow an inspection of the property.
Property.
Period. That's the end of the motion. All right, this was a previous draft that didn't get updated. And I just didn't notice it either. So it's just moving, so the order is to set up an inspection of the property. All right, so the motion is to overturn the building commissioner's order to allow inspection of the property, period. Just ends right there. Right, so the original discussion we had offline was to basically acknowledge that the inspection had happened. So that's the language that was in there, and as we talked through it, it was like, no, look, the right thing to do is just straight motion and be done with it, so that's what. So, are you okay with that motion?
Yeah.
Do you want to read it one more time, just so we know we've read the motion?
Does anybody else want me to read it one more time? I
Get the
move
gist of
to
it.
overturn the building commissioner's order to Carlos Baez to allow an inspection of the property.
second.
Thank you. Motion made and seconded. Any discussion? Again, it's, you know, it's happened, that's great, but, you know, I think we want to upheld this.
Is this, I'm sorry, is this just kind of confirming that the inspection has been done, or that they have to allow him to come back in?
Just affirms that, you
Affirms
know,
it.
they have to allow it.
Okay, all right.
You can make it clear in your written decision that,
That
you know,
it-
You
on
can make it
June
clear.
twenty-sixth,
You can make it clear enough in this.
on June twenty-sixth, an inspection occurred, so.
Okay, all right.
Roll call.
Yep, roll call vote.
No.
Ms. Reed?
No.
Mr. Yeomans?
No.
Mr. Mia?
No,
Vice Chairman votes no. All right, so at this point, I think this ends the case. We need to, direct, council to craft a decision. And, I don't think, we don't need to vote on the overall decision. I mean, we just had these 5 motions. I think if you can just write the decision.
Well, there's a couple ways you could do it. You know, you can write the decision and then you can review it and have, you know, each board member that voted come in and sign if they agree with it. Or you could, you know, take it up at a future meeting, which would not be a part of this public hearing, and you can discuss it. You know, you can't deliberate, but you can discuss it to make sure it says what you want it to say. And if you have any changes based on what happened in these previous 2 meetings, then we can change it. But it's really up to, you know, what you prefer. There's no wrong answer.
Yeah, it seems, so we don't necessarily need to vote on it, right?
You don't have to
There's
vote.
not a decision. This isn't a comprehensive permit or a special permit. We're voting on the overall decision. But it seems to me that I think this board generally is gonna want to at least see that decision before we sign it.
Yeah.
So, yeah, it seems to me you should draft a decision for review at our next meeting. And we can close case and, case number 6, 8, or 9.
Well, so it's closed, so
It's
the
closed,
public
public
hearing
hearing,
is
we've already done it.
closed, so you can, it's like an administrative
Yeah.
agenda item.
Yep.
Like no public comment, you
Minutes.
know, anything like that. It's just, you put it on the agenda because you're gonna talk about it and
Right.
then you can,
Okay.
But don't we
Just say-
need to issue the decision within?
Well, I was just gonna get to that. We do need to, there's a timeline we gotta deal with.
yeah, so I think I watched the last meeting. I think Chris Heap's math was August something. I don't remember the date he said, but
Okay.
we can, whenever your next meeting, and we can have one ready for the board to
Okay.
review.
That may not be for,
Wait on,
we don't have, you don't know if we have any cases.
I thought she got something in today.
She's got 1 case.
Yeah, something came in today.
Probably not inputted yet.
Yeah, okay, let's, we'll plan for our next meeting, and, you guys need to check the timeline, and if we need to get together before then, you're just gonna have to let Katrina or Bob know, and if we need to call a meeting.
Yeah,
we'll call it.
I'll look and send an email tomorrow
Yeah,
morning.
okay,
We can call a special meeting
Yeah,
because
that's
there's
what-
no
right.
deliberation.
right, exactly, right, so if we need to call a meeting to finalize it, then we can do that. We'll let you guys be on top of the timeline. All right, I think that's it for case number, whatever this was, 903.
Thank you. It's always a
Turn thank you. Just going to turn it back over to the chairman.
So the next item on the agenda is 162 Old Upton Street. Seeking a special permit.
I'm happy to.
Mr. Chair, do you need counsel? Do you need counsel to stay?
I don't think so.
Okay.
You know more about what's going on here
Yeah,
than me.
he didn't.
I haven't looked at anything else.
He didn't know.
Yeah, okay.
Okay, awesome. Well, thank you.
Well, I guess I was saying, I guess my point to Bob was, I assume this is a fairly straightforward request for a special permit, right? There's no reason that we need counsel, that you know of, is there, Bob? That's what they make continuances for. I don't think we need it. Last
From
month,
last
last meeting.
This comes in, this is.
back in, Mr. Chair.
So was this open the last?
It just opened, but no, no testimony, because we had a letter asking for a continuance, so. We're pretty much starting from scratch.
All right. So was the petition read into the record?
No,
Okay.
didn't do anything. Can I get that file on the one?
I can pull it up. You want to read it from my?
Yeah, I don't have what the,
Oh.
well, I read the,
Did you read it?
Yeah, we may,
we probably did. We
Yeah,
opened it. I read it.
because
opened
we
it.
had to vote to continue it.
Yeah, so I would have had to have read the, I mean, I can read the legal
Okay.
notice. You want me to read it?
No, we did it, then we don't,
Yeah.
Would you agree that it was read into the record at the last hearing?
I
You
take your word for it, but I wasn't present. We wrote a letter requesting the continuance and didn't appear.
then we should just do it.
I mean, I could do it again just to be clear so everybody knows what it is. Okay.
Yeah.
The Board of Appeals has received a petition from, I'm sorry, Mr. Panasiri, Boston Buddhist Vihara, Inc., at 162 Old Upton Road, requesting that the ZBA grant a special permit allowing a modification of an existing driveway to comply with access requirements. The board will conduct a public hearing as a continuation on June 25th, 2024 at 7 p.m. in Conference Room A. Any person wishing to be heard in conjunction with this request should appear at the time and place designated or by letter to this board in time to be read at the hearing. Zoning Board of Appeals, Brian Waller, William McCusker, Kay Reed, William Yeomans, Peter Adams, Dippy Thomas, and Alex Mejia.
All right. And I don't believe the rules of order were read. Right?
Probably not.
All right. So the clerk just read the petition into the record. The petitioner will have 15 minutes to present. The petitioner shall present the required information, and all comments should be specific. Any opposition will also have 15 minutes to speak. These time limits may be extended only with consent of the board. Anyone wishing to speak in favor of or opposition to the petition will then have an opportunity to do so. Letters received in favor of or in opposition to the petition will be read into the meeting record. If you wish to speak, state your name and address for the record. The board may ask questions from time to time, and all conversation should be directed through the chair. After all evidence is presented, the board will enter into discussion and render a decision. At any time during this hearing and prior to a decision being made by the board, the petitioner has the option to request that the petition be withdrawn without prejudice or continued to a later date, at which time the petitioner could provide additional information favorable to the petitioner. So with that, I'll turn it over to the petitioner.
Great, and thank you. Good evening, Mr. Chairman, members of the board, Attorney Matt Eckel with Fletcher Tilton on behalf of the applicant. With me tonight is Mr. Norman Hill from Land Planning, Inc. By way of very brief background, as mentioned and read into the record, we are here this evening seeking a special permit pursuant to Section 3.4.3.5 to extend a pre-existing non-conforming driveway. The applicant, who is represented here tonight, is Boston Buddhist Vihara, also known as New England Buddhist Vihara and Meditation Center, is a religious organization which provides Buddhist philosophy and spiritual guidance to the community. The property itself, as you've probably seen or may be seeing right now on the plan, is 162 Old Upton Road. It's irregularly shaped as what's commonly known as either a flag lot or kind of a pork chop lot. Although it's quite large at over 6 acres, approximately 6.2 acres, the ingress and egress is over approximately an existing 10-foot driveway, which is located between essentially a 30-foot wide, 27 to 30-foot wide entryway, which you can see on your plan is probably plan south, assuming you're looking at the plan the same way I am. as such, the pre-existing driveway that provides access to this as well as two other properties is pre-existing non-conforming, because if you kind of follow the white outline of the driveway, you'll see it comes in and turns towards the property to the right a little tight and then turns back to the property to the left. So on both sides, it doesn't provide the required 10 feet of a buffer zone, and never could, quite honestly, because it's only about 30 feet wide. What we're proposing to do is to increase the size of the driveway to 24 feet. This was done, this project has been in contemplation for some time. There's a potential addition that we'd like to add to the property as a more formal meditation center, which would be allowed use as of right as a religious use with site plan approval. But in conversation with staff, this issue of the side yard setbacks came up, and then it was discovered, obviously, that it was pre-existing. So that's why this is coming up now. That's kind of, we know in the future, we have Conservation Commission to go through, as well as site plan approval. And in trying to make this driveway safer, accommodate two-way traffic, accommodate emergency personnel, the best course of action right now is to update it from its kind of depressed and broken 10-foot width, which currently provides really only one-way traffic, even though it provides access to 3 lots and visitors and, like I said, emergency personnel. So per section 3.4.3.5 of the Grafton zoning bylaws, it allows for pre-existing uses and structures to be extended, altered, or changed by special permit, provided that it will not be substantially more detrimental than the existing non-conforming use or structure. In this case, we believe we fit that criteria. We do not believe it would be more detrimental than the existing driveway, but rather an improvement over the existing driveway, both in terms of overall access, maneuverability, as well as I mentioned, the actual physical condition of the driveway currently. It can be, excuse me, the relief can be requested as the driveway will not be substantially more detrimental to the neighborhood. The majority of the driveway, if you know the area, it's not really visible to the public at all. 2 out of the 3 neighbors that we are expanding towards also have common access over the driveway, so we've heard no opposition to this proposal, so we don't believe any abutters are opposed or the general neighborhood. So with that, I know I'm allotted 15 minutes, but that kind of sums up the proposal right now. We're really just trying to get a special permit to bring this driveway up to code and comply with what the fire department has been asking us and what we anticipate will be required for a future site plan approval. So with that, I'll pause and take any questions the board may have.
Mr. Chair, so is there any, because I know Silver Lake's right across the street, is there any water or any issues with any wetlands or anything that this will be encroaching on, or?
So through
That's a pretty dense, I live really close to that, so I.
Sure. So through the chair, Ms. Reed, we do anticipate going through the Conservation Commission.
Okay.
There would be some work involved to make sure we have their approval as well.
Right.
Without doing a full-born site plan and everything that goes into Conservation Commission, we wanted to make sure we were in line with this board. We would certainly, obviously, be happy, to have any kind of approval conditioned on subsequent approval.
Thank you.
Now, this is a shared driveway, correct?
Correct.
And are there easements for the other properties? Or is this owned by this parcel?
The driveway's owned by the parcel, correct, yes. So it's located on this parcel, and then if you drive down the driveway and take a left, it actually leads to a property that fronts on, I'm going to mess up the road, but the main road there. And then if you keep going, you'll eventually end up on the 3rd lot, but it goes over this subject parcel, that's correct.
Mr. Yeomans?
In my due diligence, when this hearing first appeared on the agenda, I drove up to your facility, and I was frightened to think that I would have a problem there, and I think it's a tremendous improvement, and after having visited the site, I think that it's obviously a well-done improvement, and it's going to make it safer not only for all of the congregants that are visiting that site, but also will make it safer for our fire department and our first responders if there is ever a problem there where you need assistance from a town service, it really is something that is very, very well done and very much needed. And my question at the end, and I drove all the way up to your facility, and, I wanted to see just what was being proposed. And I think it's a tremendous addition to your facility. It will allow you to expand if you get the necessary approvals for the facility. But even beyond that, as I've just said, it ensures that any town employee that's going to go up there as a first responder is going to adequately perform the service for which they've been hired. So I had actually thank you and admire you for bringing it forward. That's my point of view.
Any other comments or questions from the board?
Mr. Chairman,
Mr. McCusker?
Are you familiar with the various legal actions that have taken place with regards to this driveway over the years?
I am not, Mr. McCusker.
Do you know the not the Casals, the Wyman still own the old house to the left of the driveway as you drive in? And maybe, I don't know if anyone in the audience knows.
I unfortunately do not.
All right, so what I've been thumbing through here is a fairly thick file for a very long legal action that, quite frankly, I didn't even realize got settled, but apparently it did, and I don't know how. But there's been a lot of lawyers and court cases and appeals to us and appeals to the zoning enforcement officer about this driveway, okay? So, first of all, I think what is being proposed here is great. But I'm concerned that we need to make sure that I don't even know what the settlement was for this case. The basic complaint was a variance issued by the Zoning Board of Appeals in, looks like 1994, allowed the petitioners to construct a single-family dwelling and two-car garage on land owned by, this is the Casals. So I think that's the building that y'all own up there. But one of the things is this variance is limited to the land shown on the plan, submitted and shall never be subdivided, and that drainage from the Wyman property shall not be restricted. So it's those words, drainage from the Wyman property shall not be restricted, that led to the Wymans turning around and complaining about drainage being restricted, appeals to the Zoning Board of Appeals, appeals to court. I mean, just an ongoing, I don't know how many years that it was being fought. I mean, this thing goes 2001, 2002. Looks like 2002 is when it ended, so that's almost 8 years after this stuff originally happened, right? So, are you aware of any of this?
No, I just showed up 2001, so I just missed it. That must have been Roger Dubois.
Or DeSantis?
No,
No?
it was definitely Roger Dubois.
Oh, yeah, I mean, the original goes way back to Du Bois.
Yeah.
I want to make sure that we don't do something problematic here. If somebody has some more information, I mean, through you, Mr. Chairman.
We bought this property in 2011.
Oh, please, or have a seat, or.
Yeah. So we bought this property in 2011. So we don't know we are not aware of this situation before.
Yep.
I think if there were any,
Yeah.
it would have come up through a title search.
Yeah, my name is Uday Silva. I am the secretary of this Buddhist Vihara organization.
Thank you.
So here's my concern, right? So, Casals got the okay to build their house in the driveway. And they needed to, one of the things is not have, the drainage from the Wyman property shall not be restricted. And if you go out there now, it kind of at the bottom of that driveway, there's a pipe that goes under it, right? And it's never been clear to me, because it seems like that pipe actually drains into the Wyman's property, not out of it. But regardless, it's that pipe that really was kind of the main concern. And I just want to make sure that anything that we do tonight doesn't wake up the Wymans or whatever, and next thing you know, we're all back in court again. So that's my biggest concern. And like I said, I don't know what the settlement was. Quite frankly, I didn't realize we were hearing this tonight, so I didn't come in and go through this file. That's my concern. I just don't wanna cause any problems. I assume you don't know anything about this either. File.
Where did this file come from?
Because Katrina.
Katrina had it,
It's-
okay.
This is,
To read it, okay.
and I haven't had a chance to go through it, so I
So,
do
Mr.
think-
McCusker, just maybe for all of our education, because I think this predates most of us, but
Yeah.
I believe that the house on the property that we're speaking of, per the records, I believe was 1981 or 82. So I'm just a little, I'm not sure if it's a different property that got the zoning relief, and I'm just trying to make sure I'm understanding all the back and forth and who's involved. But I think the subject property that we're here on tonight was 1981, 82.
Who'd you buy the house from? Casals?
Previous owner.
Casal? Casale?
We have to go back. We have the address.
I can look it up.
Look it up in public records.
How many houses are up there? It's just one house, right?
There's three properties that are served by the driveway. One fronts on, and I apologize, it's Route 140.
Yeah.
So you wouldn't even know they have access. That front's on 140.
That's one.
And then there's one that's further back if you follow the driveway all the way and kind of loop left a little bit.
Right.
And then the subject parcel is when you come straight through. You know, once you come through the turn, you're looking straight at the subject property. So there's three total served by it, but one appears to be on 140. And I believe actually does have an Upton Street address, not an Old Upton Road.
Is there someone living in that property, that white house that's set down low on?
That's the Wyman's. The one to the left of the driveway?
No,
It's
it's
right on
as you're
140?
going in, it's, as you're going in, yeah, it's on left on the corner.
It looks like it's about to fall over.
Yeah.
Yeah, it divides to two and, yeah, the both properties.
Is there someone living in there?
Yes, yes.
Oh,
Yes, there's
It
somebody.
was the Casals that it was purchased from in
Okay.
2011.
Okay,
Yeah.
okay.
Which I just, for the record, I just want to make sure, because the building record said 81. I don't know if they got a variance to add on to it or build a new house
Yeah,
20 years after, or 10
And
years after
actually,
it was built,
there's-
but.
there's stuff that goes back in here, it goes back even further than that.
I mean, I completely understand the position of the board. We have spoken with our abutters and no one had an issue with it, which is, you know, why we're here. And obviously there's, I don't know if anyone's going to speak in opposition, but we haven't heard any. So I completely understand not wanting to ring an old bell, but we didn't see this as an issue because it's, quite frankly, an improvement to all three houses that are using the access. So.
Could we just add a condition saying that it will, I was going to say comply with any prior orders, but that puts the obligation on you to figure out what that was
Well,
and why.
but I don't even think we need to say that, right? So if there's an order that says they shall not affect the drainage, that order exists, or if it's part of the variance, that exists. So it's incumbent upon them to make sure they follow it.
Or whoever it
Or-
impacts to
yeah.
enforce it.
Yeah, yeah. So I guess my main thing, I don't know how it got settled, and I just didn't have the time to go look. And it's more just raising awareness for you guys, you know, and I think you guys should be aware that this has happened in the past and how it may affect you. And, you know, like I said, I don't know if the Wymans still own that property or not. I suspect they do, just the fact that it still remains completely unimproved. I don't know if the two older folks are even still alive at this point. But regardless, I'm in favor of this. I think what you're doing is right. I just want to make sure it's not, we don't open up a can of worms or we cause any other problems. So I'm just trying to find the sheet.
we can deliberate and vote to approve this. And if in your due diligence that you're gonna have to deal with, you know, to do that back research, it's your issue to be dealt with. not ours.
Right, I agree.
And they could always apply to modify it
Yeah.
if needed.
This member would not want to see this tied up with having additional research before we were to vote on it, because I think it benefits all of your participants and the town, the fire department.
All right, Mr. Chairman, I haven't done anything for findings yet, because I was looking at that other folder. So if I may,
Please.
yeah, so the only thing we're modifying is a driveway, right?
Yeah.
All right, okay, so this structure was built in, what do we know? Do we have a zoning determination? for
No,
this?
you do not have a zoning determination. I was on vacation.
All right,
Should be on this. What year?
what year was it built?
1981.
1981. All right, so what makes this a pre-existing non-conforming? And maybe it's in your memorandum that I read last month. What makes this, right now, I'm just trying to get the required statutory findings. So what is it that makes this a pre-existing non-conforming structure?
Absolutely. So the bylaws require a 10-foot buffer zone on either side of the driveway. Pre-existing on both sides at certain points throughout this driveway almost go right up to the property line. So we're at some points right around a foot. So it's pre-existing non-conforming in that it does not have 10 feet on either side.
All right, I'm gonna say the driveway. It's built in 1981. So that's finding F1. Bylaw requires 10-foot buffer. The 10-foot buffer along the property line. Then finding F3 is that the driveway has essentially no buffer points.
At certain points on either side, that's correct.
Yes, and then based on findings, let me go, get rid of all that. So based on findings F1 through F3, the driveway is pre-existing non-conforming. Oh, we've never done that before.
Doesn't it have to predate the bylaw? Be pre-existing?
Our bylaws are May 12th, 1986.
Oh, really?
I would not lie to you.
There you go. Thank you. Current use is,
That was way early.
1954, but that bylaw that we're talking about is 1986. May 12th.
I think that's all we need for those findings. We're only dealing with the driveway. It's not the use. We're not changing the use. So it's really just those three findings, I think, is all we need.
Section of the bylaw if they need it.
3334.
Yeah, no, we're good. I think we're good.
Allowed you that.
I don't think we need any more findings in those three.
All right. Is there any public comment? Anyone else in the audience? Is there anyone online? Any further comment from the board? Hearing none. This time I entertain a motion to close the public hearing.
So I move, second.
Motion- Oh. Sorry. Hold that.
Hello, I'm Janet Miller. I live at 150 Providence Road in Grafton. I'm relatively new to the New England Vihara Center. It provides a very welcoming environment for the community. Any and everybody is welcome to come to learn about Buddhist teachings, to decompress after a work week with meditation. The improvement of the driveway would make the trip up just a little bit awkward. Less awkward, actually. I'm probably 5 minutes away. And there's an expression called mindfulness, being mindful of everything you do. The current driveway extends that to mindful driving. You're watching every inch. An improvement, the proposed improvement would widen the driveway. It would make access safer. I've never felt unsafe there, but if we needed police service or fire or EMS, a widening of the driveway would make it quite a bit more accessible. Coming and going, a widening would make it a little bit less awkward to get out. I'm there in I'd say from 7 to about 8:30. There would be more room to move, to get out and go home. It would be an improvement to the building, and it would not interfere with anything else in the neighborhood. It would make it a much more accessible place, not only to first responders, but for the entire community to come and to learn about our traditions. Thank you for your time.
Thank you.
Thank you.
Any other further comments? So,
Actually, I do. And I apologize again, because I was focused on something a little bit different. And this is maybe to Mr. Hill. The pipe that goes underneath the driveway today, that's gonna remain?
Yes.
So, it needs to be extended, I suppose, right? You're making it wider.
I'm sorry?
It'll need to be actually extended in some way. It need to be
Yeah.
made wider.
Yes, a little bit. Yeah.
Okay. And I just, and that's on this print here somewhere. It looks like that, maybe it's not on the print. Maybe I'm looking at something else.
Yeah, this is not a detailed design of that
Okay.
proposed work yet.
Okay, all right, so it's not on there. All right. So I think the
we didn't close the hearing.
right, no, I just want to make sure I understand who, so the property is owned by, and I'm not even going to try to pronounce the name, but Boston Buddhist Vihara, that's who owns the property. So that's who the,
Correct.
and then it's modification of existing driveway, is this drawing that we have here, is that sufficient, we say, in accordance with Exhibit A?
Yes.
That'd be fine? Okay, and that's, looks like it's got a date of April 26, 2024?
There should be two sheets, the cover sheet, which is an overview, and then the detail sheet, which is sheet 2 of 2. Should be
Yep.
2 sheets.
All right, so we'll make them Exhibits A and B, I would think.
Yep.
Right? Go backwards. Maybe like this, probably.
Yep.
Want to close it? Close it.
So entertain a motion to close the public hearing.
So moved?
Second.
Motion made and seconded. Do a roll call vote. Ms. Reed?
Yes.
Oh, actually, we need to appoint, we'll appoint Mr. Thomas as a voting member in this. Mr. Thomas?
Yes.
Ms. Reed?
Yes.
Mr. McCusker?
Yes.
Mr. Yeomans?
Yes.
Chairman votes yes. The public hearing is closed.
So I move, Mr. Chairman,
Please, Mr. McCusker.
move the Grafton Board of Appeals. Essentially, my motion is going to be the beginning of the legal notice. So I move the Board of Appeals grant to the name that I'm not going to try to say because I'm not going to do it right, Dash Boston Buddhist Vihara Inc. For 160 Old Upton Road to allow modification of an existing driveway in accordance with Exhibit A. Let's just say Exhibit A and Exhibit B. So we'll just, did I say special permit?
No, not yet.
You didn't, you missed the special.
Oh, yeah, because I got so focused on names. Grant a special permit
Yeah.
Thank you.
2, then the names for 160 Old Upton Road to allow modification of existing driveway in accordance with exhibits A and B.
So moved.
Second.
Motion made and seconded. Do a roll call vote. Mr. Thomas?
Yes.
Ms. Reed?
Yes.
Mr. McCusker?
Yes.
Mr. Yeomans?
Yes.
Chairman votes yes. Special permit granted.
Bill, they'll need to sign those.
And I think we just use mine. This is case 905.
Yep.
Thank you, Mr. Chairman, members of the board.
So we'll just
Thank you.
need somebody to,
Sign these.
sign these as exhibits A and B.
I think it should be someone from the organization.
Yeah, it should, either that or, I don't know, counsel, you wanna sign them? Somebody can acknowledge that these are exhibits A and B?
They don't want to sign.
If you just sign and then print a name underneath there for me, please? Thank you. You're gonna do it here and on the next page as well. And then, print a name, please, and then.
Do you mind if you take a picture
Sure.
and signing?
I think you should. Well, it's been years. Yeah, no. Get a better picture right over there. It's been 5 years. Congratulations.
Thank you.
Oops, I'm in the picture.
It's gonna remain for years now.
Thank you. Oh, gotta do it again. Yep, same thing. This is exhibit B.
This presentation did calm us down a little bit.
This has been 5 years in the making?
Yeah. We didn't want to go this route.
Everything on this property takes forever.
Thank you.
And after you're all done with this,
Yay.
I'm gonna drive up that road again.
Me
just
too.
to-
I'm gonna jog.
Just to
up there.
visit.
So, this goes over.
Yes.
When you see this white-haired guy in a blue Honda, you'll know who's coming up the road.
You're welcome. Thank you.
Well, wait, just so you know, I mean, our secretary needs to type up the decision. We need to sign it, and then there's a 20-day appeal period. At the end of the appeal period, you need to pick up a copy of that decision and file it with the Worcester County Registry or whatever is appropriate, so, make sure you do that. That's an important step in the process as well, and hopefully your counsel will advise you that.
I'm sure he will.
Thank you all again.
Thank you so
Thank
much.
you.
Good night.
Best wishes. We have 1 minute.
Do we sell on the next meeting date?
I don't have anything, I think she'll have to email us, won't she?
No, we need to decide now, because
Oh, we
this is
do?
Logan Path, we got continued to today, so we need to
yeah, that's right.
reopen it and then, continue it to some date.
So we have to vote to reopen.
No. I don't think so.
All right, so. Lost my agenda.
9:06.
906. Thank you. So we'll reopen case number 906, Logan Path. And they requested a continuance, which has been added to the record. We need to pick a date for our next meeting. August 22nd.
That's what I was looking at. If there is a new case coming in, that'll give Katrina time to advertise it. She probably has time to advertise for the 15th as well.
And I'm away that week, or that day.
Yeah, I'm away that week as well.
I'm good on the 22nd.
Yeah, me too.
I'm good.
Anyone else?
I'm good.
All right. So.
Good.
Case number 906.
So
maybe just to keep it clean, I move we continue case number 906 to August 22nd at 7 PM.
So moved.
Second.
Motion made and seconded. Mr. Thomas,
Yes.
Ms. Reed,
Yes.
Mr. McCusker,
Yes.
Mr. Yeomans,
Yes.
Chairman votes yes.
No. Because you weren't here for the original. We heard testimony, so I think Alex.
Oh,
Mm-hmm.
Yeah, you need to get
So-
Alex's vote.
Mr. Mejia.
Yes.
Yeah, so
Chairman's vote is stricken.
Amber, you get that?
Chairman strikes his own vote.
Okay.
All right, so. So that, and so for the next meeting, or we don't know if there will need to be a special meeting to review the order for the decision on, East.
You don't even
You
know
guys will
what, you
figure
don't
it
even
out.
know what the date is yet, the deadline date.
Right, I'm just saying that that'll be, you guys, we'll have to figure that out separately. If a special meeting is needed for that.
Are we gonna need a special meeting if, let's say, Bill or you came in to review?
The
Well,
decision?
wait,
decision.
so we're talking about East Street right now?
Yeah.
Yeah.
Yeah, I think with the consensus we discussed during the hearing was, that we would review it as a board. So I think it gets added to the August 22nd,
Oh, okay.
meeting.
Yep.
And if they come back and say we need to do something before August 22nd, then we may have to call a special meeting and whoever's here is here.
Or we could do it on Zoom.
Well, that too.
Yeah.
Right.
Okay. Did we have minutes?
No. There's no minutes.
There's no minutes.
Okay.
Mr. Chair, before you close the meeting, I just want to bring one thing. Town meeting's coming up sometime, and I'd like to start thinking about changing 3435 pre-existing non-conforming. I've been looking at other towns, I've been looking at Mass General Law, and we don't have the words reconstruct. And it might be a good idea to start thinking about, does the board want to entertain under 3435 instead of extending, altering, changing? If we put the word reconstruct in there, they can take that house down and then we wouldn't have the problem. And you could still give them the special permit. It's just, since that 9 Logan Path, I've been out looking at other bylaws and I see that several of these towns, which we can bring in and show you, have the words reconstruct. It's just a thought to bring up.
And what does it say now, Bob?
Pre-existing non-conforming structures can be altered, extended,
Oh.
changed by blah, blah, blah. And if we add reconstruct,
Right.
that means they don't have to keep that one wall that happens to fall down. And they can take that foundation and rip it out and move it to a better spot if they want to, just like 9 Logan Path.
To just add that word reconstruct to it.
But that adds, that
Yeah,
does
adds
a lot.
Yeah, okay.
And because this has come up before, I think it might be time. And of course, you would have to do something and then bring it to the select board and the select
Yeah.
board go to planning board. Because who would sponsor it? Would it be you or would it be planning?
So, that's what, I was just gonna ask that, why do we need to be involved at all? Because that just seems to cloud things.
Well, if I go to the planning board and I say I'd like to change this bylaw, which I've done before,
Yep.
they turn around and say, well, nobody's really come up and said that there's a need for it. So just because I'm bringing up and I say, I really think there's a need for this, sometimes they don't listen to me. So
Point to 9 Logan Path as an example, or any other.
I've tried with signs. Right, I've tried it with other things and I just get thrown back because it really wasn't their idea. I think if this board doesn't have to sponsor it, but they could discuss it with planning and maybe planning, because maybe one board will talk to another board.
Yeah.
I think Logan Path is a prime example of the need to do this.
Oh, we have several that have been in the past.
Yeah, but
Right.
right now, we've got.
And I talked to Logan, I said, you can wait, but it might be a couple of years and he might wait.
Oh, wow.
Well, he's not in a hurry.
Yeah.
So he might wait a year to do it, but it just seems like now's the time. That's all I wanted to say.
Sure. Thank you.
Yeah.
Anything else? Anyone?
Nope.
I move we adjourn.
So moved.
Second.
Motion made and seconded. Mr. Thomas?
Yes.
Ms. Reed?
Yes.
Mr. Cusker?
Yes.
Mr. Yeoman?
Yes.
Mr. Mejia?
Yes.
Yay.
Chairman votes yes, we're adjourned.